I still utilize machine parts on the engineering room, and I've actually, my field, I'll get you accelerated too, but I got, since this is a newer technology for itself, the bulbs are very easy.
All right, you guys, let's make our way in. We've got the live streaming on www.yourmmjinfo.com for all of the people that are on the live stream at home, keeping warm. The smart people. The sober people.
I'm sober.
Lame.
That's it right there.
Technology, though, is pretty nice, right? So we have panel to the stage. Sweet on the live stream, all right. Do you want to give us the other website besides www.yourmmjinfo.com? It's Inhale TV. Inhale.tv. And that's where we're live streaming tonight. How are you guys?
Excellent.
Okay, we need Craig's mic. See, let's do a mic check up here.
Check, check.
Hello.
Check, check.
This guy, the guy in the white here. It's on the way down. We have an executive breakfast this Saturday. We have over 70 people signed up for. Investors, buyers, sellers. And like I said, we have a huge audience on our web stream tonight. No, we need to make sure your mic works actually. Important. Great. Okay, so tonight we have Craig Small. He's an attorney here in Colorado. He's part of the Amendment 64 Task Force, and he is going to be bringing us some great information today about where we're at and where we need to go with these procedures and the recommendations that we're making and how we can help him, really be a leader on that task force for us as well. We also have Rachel Gillette. She's on the board of Normal, a Colorado attorney who has worked on many tax audits and specializes in cannabis law. So we're glad to have her here today. We also have Matt Kuman, all the way from California, one of the biggest tax attorney specialists in our industry. He's worked on both the Olive case and the Champ case in California, and both of those cases are one of the reasons we have the 280E, which is where they say that you can't write off certain expenses because of illegal services. So it's going to be amazing to hear his expertise tonight on this subject. And we have Clifton Black from Colorado Springs, attorney, specializes in cannabis law, and very much appreciate his opinion here tonight. So thanks for being with us. So Matt, do you want to kind of go into the opening of what is 280E and how is that affecting our industry right now?
Okay, thanks, Chloe. It's a pleasure to be here in Colorado. Although I was commenting earlier that I feel a little bit like a relic since I've been practicing cannabis-related issues since 1996. 280E was enacted by the Senate Republicans in 1982 after they were outraged by a tax court case in which a drug dealer was allowed to deduct all of his expenses on his tax return. So they enacted 280E, and basically it says that if you are trafficking in controlled substances as defined by our Controlled Substances Act, our criminal law at the federal level, you cannot deduct your operating expenses. Now, what that means is actually that you can deduct the expenses related to if If you're purchasing cannabis for resale, that's deductible. And that's funny. Why do they do that? Well, it turns out that the United States income tax can only tax income. So if I have to spend $3,000 for a pound of cannabis, and I understand now, of course, in Colorado, you got to be linked to, the cultivation has to be linked to your dispensary. But for a period of time there, it wasn't quite true. And in California, we still have a very different setting. But if you pay $3,000 for a pound of cannabis and sell it for $6,000, how much income have you made? Anyone? $3,000, okay? So you can't tax the other $3,000 that you've recovered. That's your cost of goods sold, or they call them COGS. So that's a significant issue, and we're going to come back to that throughout the evening, because as a practical matter, one of the first things you want to do is make sure that you allocate and that your CPA or your bookkeeper or whoever you're working with puts as much of your expenses into those categories. And COGS isn't just a material cost. You can actually have a COGS expense for labor. So if you have people working in a back room, trimming cannabis, bagging cannabis, weighing cannabis, testing cannabis, those folks can also be considered a cost of goods cost of goods sold cost, and can be deductible as long as you can substantiate it. We'll also talk about what substantiation means and how that plays into all this. So, in its fundamental way, that 280E basically says you can deduct your cost of goods sold, which was screwy. Like, we're going to punish drug traffickers, but we're going to let them deduct the cost of the goods sold. I mean, what were they thinking? And then, well, they were stuck with this income tax issue, because otherwise they'd be challenged and the law would be ruled unconstitutional. They'd be back to zero. But they could legally say you can't deduct your operating expenses. Now, let me tell you about the Champ case. Back in the 1990s, when I was starting out this practice, we had a handful of medical cannabis operations in San Francisco. That's where this whole movement started. With Dennis Perone and Wayne Justman and people who probably many of you have never heard of. They were starting the dispensaries, they were starting to operate these clubs, we call them. And I was looking at the situation saying, well, what besides the criminal danger of running a medical cannabis operation is going to sink or potentially submarine a medical cannabis operation on the civil side, right? There's criminal and civil. I knew the criminal was always going to be there. It's still there. We still have busts. We're still dealing with the criminal. But the other issue we know, since this industry is emerging into a quasi-gray area, and we're hopefully emerging out of the black market and totally into a legitimate industry, what do you do on the civil side? And I started looking at the tax code, and I saw 280E, and I said, that's not very good. And part of why I wanted to look around was because I wanted to be able to advise my clients what they were going to confront going forward, what was going to happen if they actually did this business and got permits and paid taxes and all that. So I told everybody, I said, until we resolve this 280E issue, I would not advise you going into this industry, because you're not going to be able to run a viable business and be unable to deduct your operating expenses. That was the problem. So we looked around for a test case, and lo and behold, one of my clients, Champ, which was a corporation, that'll be significant when we talk about the Olive case, because Mr. Olive was not a corporation, and that plays into how that case came out. So in Champ, we found my client was shutting down the operation in 2003. We talked about what to do with the tax return. We agreed we're going to file the final tax return for half the year that they were in operation. And and in the conversations that we had, we discussed what would happen if there was an audit. And we actually looked forward to the audit. We're probably the only people in the United States that was hoping for an audit, because we wanted to challenge 280E. We wanted to put a challenge in the face of the government and try to turn 280E on its head. So Champ was perfect. 47% of it. If you've never read the Champ case, it's a wonderful case. It gives a lot of interesting ideas about what you can do with your businesses. It's still valid law. It's still important. It's noted at 128 Tax Court number 14. It was a 2007 case issued by Judge Laro. You can get it on the Tax Court website. and it's called Californians Helping to Alleviate Medical Problems versus Commissioner of the IRS. Very interesting case and very readable. Now, what happened when the IRS did the audit in 2005, we were excited because we finally had our impact case. Lawyers, we talk about impact litigation because that's the kind of litigation you look for to challenge a law that you don't like. So we brought the case. The IRS didn't know what was lurking. They had no idea. The corporation had been out of business for 2.5 years. There was no personal liability for any of the individual operators, the managers. They were all corporate employees. This was strictly a civil matter, not criminal. It was against the corporation which filed the tax return. Champ ended up going through the audit process, and by the end of the audit process by the IRS, the government wanted $425,000 from Champ, a defunct corporation, shut down 2.5 years earlier, and they wanted it in penalties and interest and in the underlying tax that they claimed was due because of the 280E. You know, you can't take the deduction for the operating expense. By the time we ended that litigation, the tax court judge fell in love with Champ, fell in love with the operation. We had services for patients, we had food, we provided shelter, we did all sorts of things for the patients. It was a really wonderful operation. The judge saw that, and basically by the end of the case, the judge said, you know, I understand that the government has a law that says that drug traffickers can't take deductions, and I see that some of what Champ is doing is a drug trafficking operation, and therefore I'm going to allow the government to deny these specific deductions. But there's also something else going on at Champ, and there's something bigger, and the organization is actually doing something called caregiving services, or providing assistance and social service in the community. And I'm going to find that most of those expenses were related to doing that. So by the time we were done with the tax court, the judge said that we didn't have to pay $425,000, we had to pay $4,905. So the difference, the 1% of what the IRS wanted was significant. Now, the IRS, during the course of litigation, was desperately trying to get us to settle the case. They didn't want to drop it. We said, drop it if you don't like what's going on. They wouldn't drop it. They just offered us very low numbers that in any other tax, like Rachel does, just regular tax cases, if you got those offers in a regular tax case, you'd be jumping on them like white on rice. I mean, it was incredible. So, but they wouldn't drop the case, and they went forward, and we got the first ever decision on medical cannabis taxation in the federal income tax system. And that was great. So then I went out, and I started talking around the country, and started talking to you guys and industry people, and here's this decision. I finally got the decision that I looked at not 10 years earlier in the 90s. We got it in 2007. All right, here's what you got to do. And everyone looked at me and said, Matt, you know, go fuck yourself. I mean, that's pretty much what they said. I mean, it was, I know I'm on TV here, but basically, you know, we're here to make money. We're not here to take care of people in a kind of rough way. That was essentially what it was. So there wasn't really much that we could do other than say, these are some techniques you can use. You can try to develop services. I mean, I've even talked to people about setting up a health center and a gym, and you can do all sorts of things that you could have and then minimize the kind of expenses that are actually involved in trafficking as defined by the tax court. But no one's really picked up on it. And you guys out in Colorado, which is, you know, my applause to Colorado, you guys are like in the lead on all this cannabis stuff. But there is a looming menace that we have to be ready for, and that is the IRS. And Rachel's going to talk more about what the IRS has planned for all of you out here. I'm here to talk a little bit during the course of the next hour, and I'll be quiet pretty soon, about some of the concrete steps that you can take when and if you face some kind of an audit, and what you can do to try to shield yourself from the worst prohibition type laws that the IRS is trying to impose on you. We saw some of the problem. People were not listening in the Olive case. Martin Olive was also a client of mine. He came to me with the audit notice. He had actually came to me because the IRS showed up at his front door with 2 investigators from the Criminal Investigation Division, which we are seeing some of that. There is criminal investigation grand juries being opened because they're looking for tax evasion. which is basically people scooping cash out of the cash register and not reporting it, based on a number of things. The IRS can subpoena documents from the bank and so forth. Mr. Olive did not have a corporation, so he was personally liable. For those of you who looked at Olive and wondering why that case went up to the tax court, because he was going to get a better break, and he did get a better break in the tax court than what the IRS was going to assess him for. But he's personally liable for now something like $1 million in taxes. He did not have a corporation. Does everybody have a corporate entity here? Anyone not have a corporate entity out here for their cannabis-related business? Okay. Anyone you know in the cannabis business, they have to have a corporate entity, not because it's going to protect you from criminal charges or anything related to anything criminal, but on the tax side, that entity is the taxable entity. There's a couple of twists on that. If you don't pay your payroll tax, they can come after a director or an officer of the corporation. So make sure you pay your employee payroll taxes, otherwise you can be personally liable for those. And in California, at least, your sales tax, you can get in trouble personally for not paying your sales tax if you're a, I don't know if is that true out here as well? Yeah.
Yeah. Yeah, that's my question. Some of these people set up LLCs, and I know that was required at the beginning.
It's a corporation, but if you elect to be treated as an S corporation or treated as a partner, as a pass-through, then you're going to be personally liable for taxes. So, Rachel, again, and I, agree that certainly in Colorado anyway, you want to be a C corporation. You don't want to have any pass-through to individuals. So you want to be a C, not an LLC, and not a C with an S election at the federal level. A lot of people say, oh, I'm an S cooperative. Colorado doesn't have S cooperatives. Colorado has corporations, and they have LLCs. You can elect to be treated by the federal government under subchapter S of the Internal Revenue Code, and that's what subchapter S is. In the short, the moniker for that is a S corporation. It means that the money comes in and it's not taxed at the corporate level. It goes all the way through to the individual, and then that individual pays taxes on that based on how much money they've made. So Mr. Olive, unfortunately, had quite a different story from the Champ case. You can read that decision too, and you'll see a little bit more. We, of course, since put the vapor room into a cooperative corporation. It was too late. Meanwhile, the federal government came in and sent a letter to the landlord saying that you had to the landlord was going to lose the property. So Vapor Room, which was the entity that Mr. Olive set up, was shut down due to the federal intervention, as were a number of them in the Bay Area by the federal government. So those are essentially the two cases. And what maybe I'll stop talking now and turn over to Rachel, because there are some specific lessons from it. There are some things that we can do going forward. Unfortunately, the main tactic or the main issue right now is we're talking to the IRS agents and saying we want to push this back because we're hoping that some federal legislation is going to come in and retroactively fix things going forward, because it's just, the whole thing is a mess. So I'm going to stop now and maybe turn over to Rachel or Greg or Cliff, whatever.
Sure. Okay, so what I think is very important to note here is the differences between the Champ case and the Olive case. Basically, the Champ case said that you could carry on more than one trade or business at the same time. And so the trade or business that you were carrying on, which had to do with your caregiving activities, you could deduct your ordinary business expenses associated with that trade or business. But the trafficking of marijuana portion of your business, you could not under 280E. Now, there's some fundamental differences. Basically, with Olive, the tax court basically said, you know, your only trade in business here is that you're trafficking marijuana. You're not really providing any other services. You know, all you do is really sell marijuana. You don't offer any other products. You don't offer any other services. Although in Olive they did provide, I think, game playing, and they taught people how to use vaporizers, and they taught people, I think, how to smoke marijuana.
Well, there was they also were basing it on medical reports that said that people who have any kind of illnesses do better if they're around other people. So there was a social aspect to it, and people could stay there and meet there and be part of the club. But the tax court was not impressed with that.
Yeah, there was a big difference with the Champ. I mean, Champ, they were providing yoga classes, they were meeting outside of where they distributed the marijuana, they were providing food and other services.
Really good wings. I had some of those.
Yeah, and Olive was a sole proprietorship, so I definitely would recommend that nobody set themselves up as a sole proprietorship or flow through an entity in light of what's happening now in Colorado, which what we're seeing is, we are seeing the IRS come in, they have a program basically where they have decided to audit this industry. And it's not something that's really unexpected because they've done it in California and now they're doing it in Colorado. And they understand in light of Olive, which just came out last year, right? So Olive just happened and they've got this favorable ruling that says if all you do is really distribute marijuana and that's your only trade in business, you know, you really can't deduct your ordinary and necessary or ordinary business expenses. So they saw, I don't know, maybe they saw an opportunity or they wanted to take a snapshot of what's actually going on here. But they are auditing, I think, about 10% of medical marijuana businesses in Colorado, and they've made a conscious decision to do so. So if you're one of those businesses, you know, you have to be aware of not only how you can protect yourself in the future, but you know what you need to do if you are going to be audited or you are chosen for that audit. Because I certainly would recommend that you get counsel.
Don't talk to anybody.
You do not talk to the
except for the lawyer who's going to represent you.
Right.
Not talk to the IRS.
Yeah, that you get counsel, you have a representative, and then you think about how to structure your business or change things in light of what we have today. I mean, we definitely can talk about what we can do in the future to hopefully change 280E, maybe make it retroactive, any change of 280E. There are some positive developments in that area, but you have to be prepared. And one thing I think that our industry has not thought about, which Matt brought up very wisely, was that, you know, we need to think about how we didn't take advantage of the Champ case in Colorado, much to your dismay.
Look, it's just water under the bridge. I mean, now the question is, what do we do going forward?
That's true.
That's our game now.
Right. So essentially there are some things that you can do to think about how to leverage Champ because it is still good law. Olive was a unique case. It's a sole proprietorship. There wasn't a lot of documentation provided, and really there weren't other services that he provided or that the tax court found that were legitimate. So you can think about your business in a way where you can take advantage of Champ. And essentially, do you have some recommendations, Matt?
Well,
I have some, but okay.
Just with a show of hands, has anybody considered doing more than just what the government would call trafficking? Is anyone thinking about doing other kinds of add-ons to their business or?
Well, in our state, caregivers have to provide other services, and they're not allowed to sell cannabis for profit. And then the actual medical marijuana centers, you know, a lot of them do have other services that they provide, but I wouldn't say that they make quite enough that would even count half of the build-out that they would have on one of these warehouse facilities, or half of the money that it would cost them to staff an entire retail and warehouse location, which is really 280E it's retail. I mean, I think that maybe they want to understand a little bit better what can they and can't they write off.
Well, you know, if you look at a spectrum of things you can write off, say that you've got, say you're doing yoga classes in the facility. You know, for sure you can write off the instructor's salary. For sure, any staff time that went into setting up and interacting with the instructor, any staff time spent with the employees, you want to document that. You know, if you have a percentage of your organization that is doing kind of yoga or massage or other services, any of the administrative full-time equivalent, which is another word for employee working 40 hours a week, if you can show and put a job description out So that shows that they're doing non-trafficking related things. I always try to get my clients to have job descriptions for people that show that they're doing non-trafficking, or that they're customer service, or something that doesn't have, you know, the word cannabis, marijuana, weed, like that in the job description. So that at least you have some documentation. I mean, I'm dealing with the IRS all over the country now and dealing with their agents. And, you know, if you show them documents, you know, they have to sort of pause. If they see a document that's got evidence that there's other than trafficking going on, they have to take that into consideration. They can't ignore that. You're not going to get walkaways, meaning, you know, they're not going to just walk away from the audit because you show them a bunch of documents. But you can have your documents lined up. And I mean, and honestly, you know, I know this, I've been around this industry now 17 years, and paperwork's not your strongest suit. Okay, it's just not.
But it's important.
And that's okay. You got people like Chloe, you got lawyers, you got all sorts. You can hire, you know, good kids from Boulder out of college and Colorado College, and you can get people to help with your paperwork, because it's really important. It actually does make a difference in so many different ways, in so many circumstances. And I've consulted around the country, Rhode Island, Massachusetts, Michigan, New Jersey, you know, and the more paperwork people have, the more they're providing a professional approach, and paperwork is evidence of that, the better they do. Now, the other thing that happens during audit is they negotiate. One of the things that's happening, and we just successfully got a client to negotiate before we had to file the tax court petition. Because the way it works is they audit you, they issue a deficiency notice, basically say you owe this, and then you either pay it and negotiate and pay it, or you can go to tax court, and that's your appeal, and then you go and you have a tax court hearing. So we were able to negotiate, you know, payment schedule and things like that. It doesn't answer the issue, though, what do you do going forward? Like my client that I negotiated for, he could get audited again. He's not really doing it. He didn't really change his operation. So he's still really trafficking. He's still facing the 280E problem. So unless the laws change, and basically if I were really urging everyone to do something, I would like put whatever money you have and hire a lobbyist, a hotshot lobbyist firm in Washington, D.C., and get this damn law changed, because it's just going to continue to dog us. We can do everything right. We can make all, you know, all the regulators in California and the Department of Revenue, we can make them all happy as hell. But if we can't get the IRS off our backs, it's just going to be one, you know, messy, sloshy battle going forward. So I think ultimately we have to get that legislation passed, whether it's, you know, simply going forward or ideally retroactive. That's what you have to do. Now, during an audit process, I just want to say, don't talk to the auditor. Just you'll get a letter. They'll say, call me. You don't call them. You call your lawyer. You're going to have to hire lawyers. I'm sorry, I don't mean to pitch us here. It's not self-serving. You don't want to go into this on your own. They take everything down. And I had an instance where the lawyer who didn't practice tax law didn't realize that everything he said to the auditor was being written down by the auditor. And then the lawyer's comments also got put in, and the lawyer had said right up front, well, he doesn't, our client doesn't offer any services. You know, I was like, hello, you know, what are you doing? Get sued for malpractice. So you got to be careful to make sure you got a lawyer who knows, you know, how to talk to the IRS, because they will write everything down, and you have to be very careful with them. They're watching. They know this. They walk into my office with the Champ case underlined and everything, and then I go, you see my name on there? And I circle it for them, and I say, I know about that case. But they just apply the law. They'll just look at the Champ case and they'll say, what are your expenses? So what are the deductible issues? You know, Chloe, back to you. You know, cost of goods, right? Jam everything in the cost of goods. Cost of goods labor, cost of goods material. Use as much as you can in the cost of goods. Make arguments, have documents, work with your lawyers, work with your consultants. Get everything you can in the cost of goods category. And that's 100% deductible, as long as you substantiate it, as long as you can show it. In Colorado, my understanding is that it's getting easier to substantiate these expenses because the state requires you to have it, right? So then, the other issue is, what about some other things? Now, obviously, the other end of the spectrum, that's deductible, yoga classes, anything that's not marijuana related, okay? Then we start moving, closer into the trafficking kind of expenses. Well, what if I have someone at the counter who's selling cannabis, and their job is not to touch the cannabis or touch the money, but their job is to talk about someone's condition and what cannabis might be appropriate for them. Can we deduct that person's salary? We haven't had that case yet at the tax court, but I would argue that you would. If I were doing a cannabis operation, I would have one person handling the money or two people handling the money. Minimize the space in the store you're handling the money, minimize the place in the store you're handling the money. And this goes against business principles, right? Because what do you want to do with your wares? You want to display them, you want to put them out there. And yet, that can work against you when it comes down to the federal tax problem. Because the more space you use and the more people are in the transaction, in the trafficking operation, that's not deductible. Yeah. We're not supposed to have questions, right? Good. Make it quick. Loud, really loud.
Just going back to that, have you dealt with the situation where, yes, 1,000 square feet, you're only, selling with this 300 square feet, so the other 700 square feet would be deductible, and that goes along with electricity and everything else?
Yes. That was Champ. Champ.
Well, I would say it depends on what other services you're offering within that facility. Yeah. I mean, if it's just your waiting room,
right.
and all you do is sell marijuana at your store, that is arguably maybe not something that you can allocate.
Right.
So, I mean, the key here is to offer other services and to make sure that you're receiving money for those services, that they're legitimate. You're not just saying, oh, yoga teacher, you can come in and use my space. I don't care what you do there, but it's just so I can, have a tax deduction.
In the Champ case, the other services they were offering were, and Matt knows this case better than I, but counseling, meals, transportation, and all that stuff was absolutely deductible because it had nothing to do with the distribution of marijuana.
Right. And that's the key. Trafficking is a narrowly defined term. It's money. Here's the cannabis. Here's the money. So if you have just one or two people, a minimum number of people doing that handling, and you have other people who are counselors, patient counselors, and have job descriptions. These are techniques that you can use. We haven't had this come up yet, but this is something that you can do that may be a measure to protect yourself going forward.
And I cannot stress how important documentation is of this. You can't just say that it's happening. You actually have to substantiate it. You have to have written job descriptions. You have to have written documentation showing, that you paid X amount of dollars to your yoga instructor, that you provided X amount of dollars for food to your patients, that you're offering other services. So it has to be documented. That's your best friend, I think, is to actually have documentation.
Chloe, can we take another question?
Yeah, we can do it.
Go ahead. Loud, though. Really loud. Because you got an audience watching.
All of these extra services.
Louder.
All of these extra services that you're talking about, are these required with Amendment 20 in Colorado?
This has nothing to do with state law.
Caregivers.
What about Amendment 64? Does all this matter with Amendment 64 licenses?
If you're providing other services and you're charging for that, it's tax deductible. Your question is it required? The only time services are required is when it's a caregiver under Amendment 20, the Constitutional Amendment for Recreational Marijuana. House Bill 1284 creates medical marijuana centers that aren't required to provide other services, but they're certainly not prohibited from doing it. So if you're providing other services, you need to charge for it, you need to account for those other services, and those will be deductible.
What about being clever? Like, for instance, if you have people who are cannabis consultants who are working behind the bar, okay, but they have to go to a med box to actually get the product out of it,
That's
but it's
trafficking.
not it is?
Yeah, you're touching a Schedule I substance that is completely prohibited under federal law.
But I mean, could you write off the tax? Could you write off your employees' salaries on your cannabis consultants, but not if they're touching the marijuana,
Right.
but if they never touch it?
That would be my position, that if you don't touch it and you don't touch the money, and you're just talking to people about medical condition, I think you have a really strong case that you're doing something, you're doing counseling, you're doing health work, really. Yeah.
That applies to recreational licenses.
Look, federal law says you got to pay taxes on everything. If you run a prostitution ring, you're supposed to pay taxes. If you run a murder for hire ring, you're supposed to pay taxes. They don't, the civil side of the federal government's taxing authority, they don't care where you get the money. They just want the taxes paid. And in the case of cannabis, they've made this little tweak thing where they're trying to screw you a little bit more by not letting you take the operating expenses. So you've got to show them that you're doing something besides cannabis trafficking in order to avoid the deductibility problem presented in their 280E statute.
Because 280E could add up to like 2/3 of your business.
Now that leads me to another question, another point. In California, there was a guy the IRS had, one of their in-house people, and he died suddenly. It's a terrible thing. He was their specialist. They are actually just trying to figure out this industry. They really are. They don't really have a bone to pick per se. They've just been authorized by the Congress to go do this, do audits, and in the case of cannabis, make sure this 280E rule applies. They're not bad. I mean, they're just doing their job. And one of the things this guy was circling around was they're coming around with a number of 50% cost of goods sold. So if you have a $2 million year business, he would say that it's legitimate for you to say that $1 million of that business was cost of goods. That was about the number they were circling around. He dropped dead. We don't know if they're going to continue that because they hadn't quite finished their evaluation. But one of the things that happened in one of the audits I was working on was that they used that number, even though my client said we had 70% cost of goods. In other words, 70% of the total, of the expenses was to purchase cannabis and prepare cannabis for sale. And he said no. He cut out the 20%, and he said no. I'm going to give you 50%.
The difference between California, obviously, and Colorado is that you have to grow 70% of what you produce. And a lot of people grow 100% of what they produce.
But what's really important to my bushy-haired friend with the glasses right over here at the front is that it doesn't matter what state law says. This is federal law, and the feds have their own way they're going to do this, and that's why this law has to be changed, because the recreational thing is going to come bumping right into this whole thing too. And then if you're talking about recreational sales, who wants to spend money trying to take care of people who just want to come in and buy cannabis for whatever adult use they want to use it for? So so that's why this whole thing you guys have done, again, clap, 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 it's amazing. Bow down to Colorado, but you're not going to get past the IRS until the federal government addresses this issue, and that's the problem. And that's why you really, for those of you who are foresighted and want to be around this business in the next 10, 20 years, because the law's going to change, and it's going to happen. It's going to happen. But the question is when, and if you want to be around, you want to start planning. One of the things that I was able to do over the years is forecast for my clients. It's easy to forecast right now what's going to happen. Cannabis is going to become more, certainly medical cannabis is going to become, at some point, probably in the next 2 to 10 years, that's the range that I kind of think of it, is going to become legal under federal law. There's no question in my mind that that's going to happen, okay? But what do you do, and then what happens when that happens? Now, they're going to have to change the tax law once they do that.
And there's actually some bills that have been introduced this year in Congress which could change this. There's 3 of them, I believe. So you need to contact your congressperson. And express your support for this change. Changing the classification of marijuana under the Controlled Substances Act would change 280E.
Sure.
That would make a huge difference.
I'm working with a team of attorneys in California. We're going to be up in the 9th Circuit Court of Appeals on the question of whether Americans have a fundamental right to use cannabis as medicine. And that question is going to be directly taken up by the 9th Circuit Court of Appeals. If we win that case, it's a game changer. So keep your eye on the 9th Circuit. In that case, we'll start putting out press and some information as we get closer to the oral argument.
And
Do you recommend that we wait as the state of Colorado for a few more states to get on board and to help us hire some of these hotshot lobbyists to do stuff, or?
Well, I don't know.
I think the bills are there.
I hate to say this about this industry, but this industry will spend $100 on buying cannabis and selling cannabis, and they won't spend $1 on lobbying and trying to change the law. It's just been my experience in 17 years. So if the industry is going to finally learn how to organize and work together, they're going to get something done. I mean, I used to be a labor organizer in Mississippi. I organized poor black guys to change Mississippi state law in 2 years, regulating the measurement of wood, the woodcutters. And you know, anyone
You're
can.
used to being disappointed.
No, I'm used to seeing people come together with a single goal, organizing around it, and putting aside their differences and making things happen. That's what it is. I see myself more as an organizer than a lawyer, because I've been able to do some pretty significant things. The Champ case, we've got a I'm going off topic slightly, but we've got a children's crusade we're going to fund. We're going to go around the country, spend a week in each major city, organize families who have kids with epilepsy and cancer who want to use cannabis. We're going to have the spotlight on them. We're going to have elected officials call, and we're going to be doing this. We're looking around. We already got industry people in California who are offering money to hire an executive director for this nonprofit organization. It's going to happen. We just have to stab the federal government where they're weakest. And we have all the resources. We have all the science on our side. We have sympathetic stories, but we're so busy with.
They don't care about science.
No, well, we'll make them care.
Well, when it hurts enough, I think this industry will start pulling that in their pockets. And I think we started when, in 2010? So I wonder how many of you actually filed right. Because when they come back and say, okay, now it's time that you owe us this much money, and you go, wow, I'm in this situation, everyone's going to say, you know what, we could have avoided this situation if we all would have came together and paid this much money and come together, because it's inevitable that everybody will figure it out.
And just so you know, they're starting their audit period in 2010, which I know many of you guys know is a very unique year, because half of the year is regulated and half of it is not. So, a lot of people don't have documentation when they were a caregiver, and then they became a licensed business or a pending licensed business in the middle of 2010. So it's a very unique year. It's going to be interesting to see what happens, and you guys have to, put pressure on the lawmakers. Jared Polis has his bill that he's introduced, which is the Ending Marijuana Prohibition Act. That could change 280E. So, if that's going to go anywhere, we need to be expressing our support for it. We need to be mobilizing a force that's not just industry people, that's everybody, because the bottom line is public policy has the public opinion on this has changed. There is a majority of this country that supports either states, making their own laws regarding medical marijuana and recreational marijuana. People that, there's a strong support for medical marijuana. And so we have the ability to pressure our people in Washington and to get other people on board. And just so you know, there are some Republicans that have joined this cause, mostly in the hemp area of it. But as you know, hemp is a part of Amendment 64. I think there were 2 or 3 Republicans that have sponsored the Industrial Hemp Farming Act for 2013. So there are people on both sides of the aisle here that we could be talking to. And I think putting your money where your mouth is very important, because if this doesn't change, you are going to continue to be treated unfairly under the tax code. And that's really what it comes down to, is you're being treated unfairly. You are a legitimate licensed business. You are doing everything you can. You're jumping through a bazillion hoops to follow the law, and you're highly regulated, and yet you're not treated under the federal tax code like a normal business.
This is a good segue, I think, because Cliff should talk a little bit about some of the criminal issues that come up. And one of the things that I talked to Cliff about beforehand was, if there is a significant, and Rachel's talking about 10% of the businesses in the state are going to come under audit. By the way, in San Francisco, we had over 25% of our cannabis businesses were audited. But 10% in Colorado is going to still be 100 to 200 businesses.
Did they say they were going to audit 10%? Was that what they said?
They're trying to take a snapshot of the industry.
So but 25% have been audited in California?
In San Francisco, in the city law. So, but one of the points was that if you have to go to the IRS and disclose your weight. Does anyone know about mandatory minimum sentences in here under federal law? Okay. Federal law says that if you are convicted by a jury and the jury finds that you grew over 100 plants or had 100 kilograms or more in your possession, up to 1,000 plants or kilograms, you go to 5 years prison. Over 1,000, it's 10 years. So we successfully argued in one of our tax court cases to the tax court judge that we didn't want to disclose weights. Why would I want to give the government information that they could put my clients away? And all of a sudden now, here we are with a law that is requiring you to potentially put yourself at risk for mandatory minimum sentences. That's, I think, Cliff's segue.
The biggest concern that I have in this industry, my background is criminal offense, and I've always been concerned about people being prosecuted. And so when you bring in this tax thing, it's a serious concern because people can go to jail for tax evasion. You basically have 3 criminal levels. If you intentionally violate the tax laws, that's the most serious, that's a felony. You could be looking at 5 years. If you file a false return or a misleading return, that's also a felony, and you're looking at 3 years. If you're a non-filer, that's really one of the lesser offenses, and that's just a misdemeanor. But, you know, taxes are a very interesting thing. I'm not opposed to paying my income tax. I want to pay less, but I'm not opposed, and I get a good return. I live in one of the greatest countries. I have the Army, the Air Force, the Navy that protects our homeland. You know, I have police and I have streets fixed, but taxes get very interesting when they're misused. I don't think they should be used to punish people. You know, we have sin taxes that tax tobacco and tax alcohol and excise tax, and supposedly that's supposed to decrease the use, and statistics show that it doesn't. But one of the interesting things that I learned about taxes was from my dad, Thomas Black, and what he told me was, you know, Cliff, you never really own property. You may buy property for cash, you may finance it from a bank and then pay it off, but you don't really own that. And if you think you do own it, just don't pay your taxes and find out what they do with that property. They're going to take that property and they're going to sell it to somebody else. Thomas Jefferson has a famous quote that says, if a law is unjust, you not only have a right to disobey it, but you have a duty to disobey it. Well, as a criminal offense attorney, I don't want people going to jail, and maybe that's kind of an antiquated saying, but we have this whiskey rebellion in 1791 where they started taxing people because they were turning their grain into whiskey and they were actually using it as a commodity. And people weren't paying the taxes, and tax collectors were being tarred and feathered. And the federal government, I think 2 different times, one time they sent 13,000 troops down to enforce the taxes or to go after the rebels, and that kind of took care of that problem. And I think another time they sent 20,000 troops. But basically the message in that is it was the first showing of the federal government willing to, having the forces necessary to, and the willingness to enforce these tax rules on people. So it gets very concerning. And if you're in this industry, you got to make sure you're doing your taxes right. You got to make sure you're filing them, and you've got to get with a good tax accountant or a good tax attorney. And Matt's kind of touched base on this a couple times. If you get contacted by the IRS, you absolutely need to exercise your 5th Amendment right to remain silent. Basically the saying I tell people is, shut the fuck up. You know, being a criminal defense attorney, I'm always amazed at how many people come in and tell me, you know, the police contacted me regarding this allegation, and so I talked to them and I kind of told them what happened, and, you know, don't I have the right to remain silent? You do have the right to remain silent, you just don't use it. You know, so anytime you're contacted by the IRS or you receive a letter, you've got to contact a Matt or you've got to contact a Rachel, and you've got to get your ducks in an order, and you've got to go through this, you know, in a methodical way and make sure you're protecting yourself as much as possible.
And I'd just like to say, you know, when we're talking about tax evasion, you know, what the IRS is looking for when it comes to tax evasion is for you not doing what you're supposed to do. And you made a very good point, which is file your taxes, keep your records, be as accurate as possible. Because they're looking for understatement of income. They're looking for you to be purposefully hiding things. And that is what's going to get you in trouble. So your best bet is to keep very good records and to be as accurate as possible. And I can't stress that enough.
And I think most people know this, but Al Capone went to prison for tax evasion. They couldn't get him on the bootlegging, and they couldn't get him on murders. They got him. They got him on tax evasion. And so that's where you need to be very careful. And you know, prostitution rings, cocaine rings, heroin rings, it's income, and you've got to pay your income taxes. And I heard one attorney, first normal conference I ever went to in Aspen many years ago, there was an attorney talking that, you know, we know this marijuana, this dispensary, this medical marijuana is a very risky business. And we know that you're going to be in violation of federal law. There's a risk on whether they're going to come after you or not. But if you're going to decide to take that risk and violate that federal law about narcotics distribution, then make that the only law that you violate. Pay your taxes so they don't have more reasons to go after you.
You know, I'm dealing right now with a criminal investigation of a client who has a medical cannabis operation in San Francisco. The Washington sent the U.S. Attorney in the Northern District a referral to open up a grand jury investigation, and he's now being investigated. And this guy did not do what the federal government thinks he did. I mean, they don't know. They think there's millions. They think you're all making millions of dollars. Okay, they have no idea about the competition. They don't understand the costs, the expenses. And some people are making good money, but it's not the majority. The majority are struggling. They're trying to keep their places open. There's a lot of competition and a lot of regulations and a lot of taxes. You got to, like in Colorado, my God, you know, you're getting taxed like crazy here to do this business. So we are seeing that they are willing to open up criminal investigations of this industry. They are willing to do that. And part of what happened with this guy was he didn't pay Social Security taxes for 4 years in a row. So when you print out his Social Security earnings sheet, you ever get those from the Social Security Administration? He had all this contributions, and then he had 4 years, 0, 0, 0, 0. I mean, just basic stuff that's just boom, there it is. Someone in Washington looking at it, that's just an obvious trigger. That's like, wow, what happened there? Let's investigate. And as soon as someone says, let's investigate, you might as well bend over and lube up, because you're screwed at that point. When the government decides to come after you, they will not let you go. Now, we're fighting it. We're trying to show that this guy is not who they think he is, but you don't want to be on their radar. If they do in Colorado come after people, I hope that the people who get audited in the state come together and come up with a legal strategy. Because one thing I would like to see is a declaratory relief action filed in federal court to show that this law requires self-incrimination, and therefore it's unconstitutional. And I hope that the attorneys in the state and the clients come together and don't get nervous, don't go into a little hole or a cave. Come out of your cave, organize together, talk about it. It's a joint problem, no pun intended, that you're all going to have to figure out here. But that's one option that you have as a class action case or an action against the federal government. Because why would you want to tell the government that you have enough cannabis to put you in jail for 5 to 10 years? I mean, what do they think we are? I mean, it's crazy. It's really crazy. So I hope that that's one idea that will get kicked around by you guys out here, and I'll be happy to come out and play with you on that playground.
Craig, as we're in the task force, and there's a question that I have for you specifically, and we were talking earlier, the term offense under Amendment 64 is referred to as criminal, but you understand that it can also be civil, as if something with taxes.
Right.
And does this mean how they're going to start fining people for something? Because it's obviously, that's a result of breaking the law is now going to be civil penalties, and that means that it's still breaking the law. So how do we get to that point, and what do you see that kind of going in that direction?
Right, and the first thing I want to touch on is the 280E. It'll be really quick. Amendment 64 Task Force did approve a recommendation to the governor to have Colorado not apply these 280E tax deductions to Colorado tax returns. I'm sure these folks up here know more about than I do. The first thing I tell my client is it's illegal under federal law and get a good tax accountant. So please listen to what these people have to say. The recommendation also calls for the governor to form a coalition amongst governors to petition the IRS to change these 280 tax deductions on the federal level. And then the third recommendation is to have the Colorado representatives and senators in Congress form a coalition amongst representatives and senators to change it. So I'm happy to say that we are pushing this ball forward, And everyone who can get behind this ball and push it an inch, even if we fail now, you know, we might succeed next year, we might succeed the year after that. So just keep pushing this ball forward. One of the things that Amendment 64 calls for is that it shall not be an offense to do these things. And I'm unhappy to say that there is a recommendation in front of the task force to say that when they said offense in the amendment, they really meant criminal offenses, not civil offenses. But what kind of sneaks in there is the fact that there are civil offenses that can put you in jail. So if, for instance, you get a cease and desist letter from your local municipality, if you don't cease and desist, you're going to be called in front of city council or board of commissioners or whatever they're going to be called, and they can issue penalties, penalties including jail time. And so you end up, even though you're in a civil realm, it's what's called quasi-criminal, and there is some Supreme Court law on, you know, what is quasi-criminal, whether it actually invokes some of your Fifth Amendment rights, and there are statutory analysis of that. And in the context of medical marijuana, these issues haven't been pushed too far, but I think once we get recreational on the books, I think we're going to see places like Greenwood Village or Adams County or Arapahoe, where they might say, all right, hey, no problem, criminal issues, no problem, we're not going to prosecute a criminal, we're just going to bring you in front of our civil boards and we're going to put you in jail that way. Now, it's not actually happening, but it is something that potentially could happen. So as a member of the A-64 task force, I can tell you, we listen to public comments. Every meeting, there's a period, every citizen is there once, can talk for 2 minutes about whatever they want, and I have seen recommendations changed based solely off of public comment. I've seen recommendations introduced based off of public comment. So I would encourage everybody, we're coming to the tail end of this, we only have 2 more task meetings, but I would encourage everybody to come to these meetings, everybody to put their 2 cents in. You may feel like you're not being heard, but it's important that you're part of this process, because it would be a shame for a recommendation to come down later on that you're not happy with, but you never really said anything about it. Does that answer your question? Okay.
Most definitely. So there hasn't been anything really set in stone on how they're going to enact those criminal penalties. So are those civil penalties though, correct?
Not for the civil penalties. There has been, and I'm not a criminal defense attorney, Cliff can speak more on this, but there has been recommendations that the 64 task force has passed to change criminal code, to adjust some of the penalty structures. But this whole civil penalty side of it is kind of flown under the radar. There's been some debate, but it really honestly hasn't gone very far.
Awesome. Okay, adjacent premises means an MMC and an MJ retail can remain in the same location, however they must have their own exits and pretty much all their own stuff. Right. How is this going to work?
I knew you were going to ask that difficult question, because I honestly don't know how it's going to work. But what they said is if you're a medical marijuana business, you can also have a recreational retail license. That's not a problem. But we're going to require you to bifurcate your business to say that you need to have, each side needs to have its own entrance and exit. Each side needs to have its own point of sale system. Each side needs to have its own inventory system. I understand the recommendation, I understand the idea, and I even understand the underlying principles of when you start putting everything together, even though that makes the most sense at the outset, when you start really, really working through the formula, everything just gets so muddled that it makes enforcement of anything almost impossible. So I understand why they were going that route, but I honestly don't know what they expect businesses to do. It's a recommendation that's going to go to the legislature. All these recommendations go to the legislature. The legislature can do what they will with it. They can throw it out, they can follow it, they can use it as a guideline, anything. So even though we're coming up with these recommendations, we're going to be anticipating that the real fight, the real battles, the real participation is really going to be in the legislative process, because that's when the statutes are going to be written and passed. And after that, the battle doesn't end. Because then what we're really going to be doing is we're saying legislature authorize the DOR to pass rules for these things. So now the Department of Revenue is going to have to go through their regulatory process and rulemaking process, and that's going to be its own set of battles. So what we're doing is good, but it doesn't end here.
Perfect. Potency servings have been a big topic at the task force meetings. What potency limits are being suggested? I know they're doing the 200 milligram bars and servings per, MIPS. I know we do have some MIPS clients that came in tonight just to hear you speak on this potency issue. So maybe you can kind of just discuss what we're facing there.
I personally am very proud of the potency issue. The Amendment 64 task force was broken into 5 working groups. One of them was the social issues working group, of which I was a member. At one point, I was the lone dissenting voice saying no potency limits. And I can say through the efforts of myself and a few other people in Colorado Normal, we did a great job. We actually turned a lone dissent into the majority. So the recommendations that's going to go in front of the 64 task force is no potency limits on anything. There's no science to support it. Thank Colorado Normal, thank the Social Issues Task Force, the Issues Working Group, everyone did a great job. Our argument was there's no science to show that anyone's ever died from marijuana. Yes, there is an estimated lethal dose, but it is in reality almost impossible. You'll die from physically eating that much of anything before the marijuana will actually kill you. The arguments against it were children are going to get sick, and we countered with this isn't for children, and we have other measures in place to protect the children. The kind of political compromise I would say we made was we said, okay, well, maybe there's no potency limits, but what we can do is we can create an arbitrary number and call it a serving size. And everyone's going to have to report what that serving size is going to be 10 milligrams. And then you just have to label correctly how many serving sizes are in this product. So anyone can really take 2 products and say, okay, well, maybe the serving size number doesn't mean anything, but this one has more serving sizes than that one, so this product's more strong than that one. I'm not really happy with the 10 milligram number, but like I said, it was an arbitrary number, and we figured everyone can divide by 10. So it made the math nice and simple. That recommendation is going to go in front of the task force, I believe, it has to go in front of the task force next week, where it'll be voted on. The dissenting opinion is asking for a 200 milligram limit on edibles, and we'll see what happens. So this is a great opportunity for everyone to show up and argue that there shouldn't be any potency limits.
When they started talking about potency limits and they wanted recreational marijuana to be a much lower potency than medical, I suggested that we just needed to get our recreational marijuana from Mexico.
And at one point I even argued, because they said, Mr. Small, are you not in favor of any limits? What about 10,000 milligrams? And I was thinking, I didn't answer the question at the time. I was thinking, all right, I'll agree to a 10,000 milligram limit, because we'll never reach that.
All right, I know we're going to do tourism. We're going to allow people to come into our state from out of state who are 21 years of age or over to consume cannabis. How is that going to work, and what limits have they put on that?
That was a battle that I think we won the battle of saying you don't have to be a Colorado resident, and I think that that was kind of the fallback position of saying, okay, we'll let people come in the state and buy, but they can't buy the full ounce. And I actually wasn't at that task meeting. Lauren Davis was sitting in as proxy for me, and she's done a fantastic job. But they're saying that if you're not a resident of Colorado, you can come in, you can buy, you can buy a lesser amount than what a Colorado resident could buy. It makes no sense. I don't, because all you're really going to do is they're just going to go in, walk in. Let's say the limit is a quarter of an ounce. They're going to go in and buy a quarter of an ounce, walk out the door, turn around, go back in, buy another quarter of an ounce, walk out the door, turn around, go back in, and buy another quarter of an ounce. It really is not really this. I don't know. I'm trying not to get too political about it, because I still have 2 more task meetings that I have to look face to face with these people. But the recommendation just doesn't make any sense. And maybe they're going to define transaction as within a 24-hour period of time. I don't know what they're going to do. Or you're creating this straw man that says, well, I as a Colorado resident, maybe I just hang out outside as a good Samaritan and say, what do you need? You need an ounce? I'll go in and buy it for you, and then I'll just give it to you for free, or give it to you at no additional cost. That way, because as an adult, unless you're a recreational business, you can't sell it to somebody else, but you can give it to somebody else. So maybe the argument is, if I'm not making any money off of it, I'm just giving it to you out of the goodness of my heart, and you just reimburse me for whatever was out of my pocket. That's giving. It doesn't make any sense.
Perfect. We're also talking about a dual licensing for both regulatory systems between local and state. Is that something that we've come to an agreement on? Or?
Yeah, it's going to be, even though the whole idea of the campaign was regulating like alcohol, they actually are regulating it more like medical marijuana, less like alcohol, which there's some positives and there's some negatives. I mean, one of the positives is that with the alcohol model, if you're a producer, you can't be a distributor, and if you're a distributor, you can't be a retailer, and if you're a retailer, you can only be a retailer for one. So obviously, that's not a free market theory, and I'm glad that we didn't go down that route. We went with the vertical integration route, which did pass, and there's going to be a 70-30 rule similar to medical marijuana, probably identical, which even the MMED, just detests the 70-30 rule, but at least it's some sort of limping along system that will continue to limp along. So they're going to do the vertical integration. Oh, you're talking about local. Let me take a step back.
Well, no, we should definitely talk about that as well, so you can keep going on that subject if you want.
Yeah, well, I'll just tie up the local versus state. So it is going to be a dual licensing model. The fees are going to be split. There'll be a $5,000 fee or more if it turns out that more is necessary. Somehow that fee is going to be split between the state and the local. You cannot operate until you have both licenses completed, but that's just like medical marijuana now. Hopefully we can iron out where it actually is a quick process rather than something that takes several months. But there are going to be some regulations on the state side if it matters of state concern. And then the local issues group did pass, or they did put something in front of the task force, but I don't think it's been voted on yet, on saying, well, these 7 items are what's going to be of state concern, and everything else is local concern. So we're definitely going to see a little bit of a patch quilt of local laws that are going to be slightly different from each other, so you need to pay attention to what jurisdiction you're in. But on the vertical integration side, that one did pass, and that one was kind of a recommendation with a bunch of sub-recommendations under it. One of them being that yes, we're going to do this vertical integration, which means that if you're the retailer, you also have to be a producer. 70% of the 100% of what you produce, 70% has to be sold through your retail outlets. 30% can be wholesale to either an infused manufacturer or another retailer. There is going to be a requirement that medical marijuana businesses have first rights to these licenses for a period of 1 year or 2 years. Again, Lauren sat in on this, and I'm reading her notes, and I honestly can't read her handwriting, so I'm not sure whether it's 1 year or 2 years. There is going to be a sunset review after 2 years, which for those who don't know, medical marijuana, 1284, when it passed and created this whole regulatory scheme for medical marijuana, had a sunset review of 5 years. At the end of 5 years, if nobody does anything, these laws go away. Something will be done. So what they did was for recreationalists, they gave it a sunset review of 2 years so that it expires the same time medical marijuana expires. The whole idea is they really want one set of laws for everybody, but unless you're going to get some omnibus bill that's going to totally revamp medical marijuana at the same time we're putting recreational in place, it really just isn't going to happen. But now we're going to have 2 years to get everyone on the same page.
Perfect. Do you think it'll be 2 years before any new MMCs open or any new licenses will be accepted in that 2016?
Yeah, I honestly, I haven't really heard anyone talk about this, but it's difficult to open up a medical marijuana business now, just based off of zoning. I mean, the market is not so much saturated as far as how many consumers can be satisfied, how many medical marijuana patients can be satisfied. There's just all these local jurisdictions have just zoned the businesses out, so there's no more room. Maybe you're lucky and you can find a little spot here and there, or a business goes out of, or someone goes out of business. But I imagine that local authorities have the right to determine the time, place, and manner. That's going to include some zoning requirements. I envision that they're going to say, we already have zoning requirements. We have them for medical marijuana. We'll just use the same ones for recreational. You can have these licenses on top of each other, and we'll just do that. So I don't think you're going to see a big boom of recreational businesses. You're going to see the medical marijuana businesses who already have that geographical location locked down. They're just going to have the opportunity to put recreational on top of it. And I mean, they're the ones who took a huge risk over these past couple of years to put it there. So I'm not sure that it's entirely unfair, but whether there's a rule on it or not, they just happen to be in the good brick and mortar place to begin with.
Yeah, they happen to make it through. Okay, so that's all the questions that I have for tonight. Is there anything else that you guys would like to add?
I mean, the only thing I want to add is please come to these meetings.
When is the next meeting next week? Can
I
you tell them?
believe it's Tuesday at 1 o'clock, 1300 Broadway, which is it's a new building. I forgot the name of the building.
I haven't at this point. So
Yeah.
we'll put it on our website, so you'll be able to see that as well. We'll tweet that and let you guys know that information. And then they can also write recommendations as well for those meetings if they can't make it.
Yes, but understand that if you write something, you send it in, it probably will not get in front of the task force. And I think
Yeah.
at one time we got a stack of paper, emails that were written in, and I've only been able to go through the first 30 pages. I think it's several hundred pages. So.
Chloe, I would just add a disclaimer, and I know we got a large web presence out there and several people here, but you know, what we're talking about up here can't be considered legal advice. The only time you're going to get legal advice is when you're sitting in an attorney's office and you have attorney-client privilege. And the biggest concern here is that for anybody's situation, everybody has different nuances to their specific situation. And so anybody, you know, maybe many people here are already in the business and have a good understanding of the laws, but you know, there's serious consequences. We talked about, you know, criminal consequences and tax consequences and civil consequences. Anybody that's even thinking about getting into this business needs to talk to an attorney. And it's not a self-serving statement. You know, I'm not looking for business. I'm not handing out business cards tonight. I'm not trying to get people to hire me, but I'm trying to get people to protect themselves. Talk to an attorney. There's many good medical marijuana attorneys in the state. We've got the best tax attorney here, in my opinion, that's done the most cases, you know, from California. He's very friendly, easy to talk to, but protect yourselves, people. I look at this medical marijuana, this recreational marijuana, I look at it as a war for the right to use marijuana. And we have all these different battles, but we're certainly having casualties from these battles. We have people sitting in jail. We have people sitting in prison. We have people that have lost their investments. So you need to be very careful getting into this business. Make sure you have good people backing you up. The resources are out there. You have people on the front lines fighting for you.
Perfect. All right, well, join us this Saturday. We're going to have an entire group here of MMJ businesses that are trying to sell, merge, investors. We're going to have a bunch of speakers here, including Matt. I know Rachel are going to be here. Let us know if you have any questions for Craig or the task force, and thank you guys all for being here tonight, and we will see you next month.
Thank you.
Thank you.
Thank you for being here.
Thank you so much.